welcome everybody, and thanks very much for coming along to listen to our session on contracts and contract management. I'm Ed Rimmel. I'm joined by my colleague Matthew Wharton. We're both partners in the commercial team at VWV, and we spend most of our time supporting schools in various of their contractual arrangements, whether that's contract outsourcing, so outsourced catering provision, outsourced cleaning, whether it's contracts with their school uniform providers, perhaps sort of facilities hire arrangements, IT services, software as a service, and platform terms. So we see a whole range of contracts for schools. And whilst we'd like to think that every time a contract comes across your desk, the first thing you do is pick up the phone to VWV and ask us for help, the reality is that that very often isn't appropriate, and there will be an awful lot of contracts which you will be managing yourselves internally. So what we're hoping you'll get out of this session are a few tips, a few insights into how we think of things when we're asked to look at a contract, and hopefully you can then translate some of that across into how you manage these contracts and negotiate them and deal with them once they're in place, where you're dealing with things without external support. Tamar, could we have the next slide, please? Thank you. So what will we cover today? We're going to have a look at what we're very grandly calling contracts as a tool for managing risk. That broadly, we're going to cover some contract basics. So what is a contract? When have you entered into it? Have you got one in place? Some fundamentals of contracting. We're then going to have a look at clarity in contracts, and the importance of getting some of the real basics there right. We think of contract as being lots of sort of legalese and boilerplate provisions and force majeure and techie stuff that lawyers know about. Actually, most things can be fixed. Most disputes can be avoided if you get the fundamentals right, if you clearly express things, whether that's around things like service scope, various sort of core obligations. Getting that clear is the most important bit, I think, that you can do when you're dealing with a contract. We're then going to look at a bit of law, so some easy wins and some common questions, so things we're often asked, things that you can, if you get it right, if you get these sort of 20% of things right, you'll fix 80% of your problems. We'll look at some terms around indemnities. What does that mean? Some issues around term and termination. And then finally, we'll look at contract management. So using your rights whilst the contract is running along, things to do and things not to do, to sort of best protect your position in terms of the relationship you've got with your counterparties. So Tamar, if we could go on to the next slide, and I'll hand over to Matthew for the first section.
Thanks, Ed, and thanks everyone for being here. I'm going to cover the first bit, having a look at contracts, some of the basics behind them, some of the legal background and structure and setup. And it's probably easiest to think, why are you entering into a contract? What's the purpose of it? And it's important, really, I think of it as looking at it as a way of managing your risk, making sure that you're protected. And a contract is a bit like insurance. If things go well, if things are perfect, if you have a good relationship with your provider, then the contract gets put in, it gets signed, it gets put in a drawer, no one looks at it, no one manages it. The relationship works well until it comes to an end. Of course, when things don't go well, which as paranoid, cynical lawyers is where we often get involved, what you're hoping for is a contract, a good contract that's there. It's like insurance. When something goes wrong, you want it in place and you want it to be there to protect and do what you want it to do. So contracts come in all sorts of shapes and sizes. One of the things we're often asked and there's questions about is names. People use names like contract, agreement, service level agreement, appointment, etc. The names are meaningless. If there's legally binding obligations between the parties, it's a contract. Now that contrasts with often things like people have documents like letter of understanding, letter of intent, memorandum of understanding, heads of terms, letters of comfort, etc. Now, these are often intended to be non-legally binding, and if they include that magic clause that says this document is not legally binding, it's not going to be a contract. But just because something says heads of terms in it, just because something is entitled letter of comfort, doesn't mean that it's not going to be a contract. So it's important to check and understand. So if we look at the next slide, what we talk here is about what is a contract, and there's some law involved here. going back to the basics, there needs to be some obligations between the parties. There needs to be rights and obligations set out between both parties. It sets out, if you're contracting with a service provider, what they're going to do and what you're obliged to do in return. Those are going to be enforceable rights, so that they will be able to enforce your payment obligations just in the same way that you're going to be enforcing their service obligations. And it's going to look at risk. It's going to look at who's responsible if something goes wrong. Lawyers always talk about the what if scenarios, and we're experts in saying, well, what happens if this happens? And you may well, that's never going to happen, is it? From our cynical experience, and lawyers are always cynical because no one ever comes to us and explains how well their contract is going. It's always a problem. There's always an issue, and often it's the thing that no one ever expected to be a problem that arises. So it's about trying to understand what that is. And as Ed said, there's always going to be a degree of proportionality in here. There's always going to be an issue that if you're entering into a contract that's worth £500, £600 a year, then it's probably not going to be proportionate to spend a lot of time and money negotiating it, agreeing it, etc. But if you have, say, a cleaning contract that covers all the schools within a 20-school multi-academy trust, that's going to be a very valuable contract. It's going to be very important to get it right, and it's going to be worth making sure that you've covered as much as possible in that. And of course, it goes to good governance. You are looking to protect your money. As Academy Trust, you manage public money. Any money that is wasted on a contract or that is spent when it doesn't need to be is money that doesn't go towards your fundamental primary purpose of improving educational outcomes. And this is all about that management of risk. It's all about minimizing the chances of things going wrong. And where you have things that are not covered in a contract, you enter into that grey area. That grey area of uncertainty, indecision, where lawyers can spend a lot of time and money on both sides arguing about something. And that's a really important point to note, is that when we talk about having a good contract in place, that means it's good for both parties. If both parties are clear what they have to do, what they're responsible for, what they're liable for, it means that you don't have arguments. So moving on, we look at, when is a contract in place? If we move to the next slide, Tamar. We're often asked, and we often get approached by schools, by trusts, etc., and there is a question about whether there is a contract in place or not. Stepping back and looking at sort of Law 101, what we all learned when we were far younger and more innocent, there are some legal requirements for a contract. There needs to be what we call offer and acceptance. Essentially, both parties agreeing what's going to be done, who's going to do what, and one party's going to provide a service, one party's going to pay for it. There needs to be consideration, which is that second point. Both parties need to be putting something in to the pot. Usually, as I say, one party is providing a service, one party is paying for it. There needs to be an intention to create legal relationships, and that is going to be the case if you're paying for a service. And then the last and one of the issues that's often discussed is certainty. There needs to be certainty about the terms of that relationship. But there doesn't need to be certainty over every term. There just needs to be certainty as to the material terms. So just because a contract is a little bit hazy or doesn't cover a particular scenario doesn't mean that it's not a contract. We're also asked often, well, we have been in a relationship with this provider. They have been providing us with cleaning or with IT services, etc., but we never signed the contract. So does that mean we can simply treat it as though it never existed and walked away? No, in simple terms. A contract doesn't need to be signed. It doesn't even need to be in writing. It's perfectly acceptable for two parties to shake hands, not even physically shake hands, for one party to start providing services to another. If the other party starts paying for those services, then you can pretty much in practical terms say there is a contract in place. The problem, of course, is that if you don't have a nice, lawyerly document signed by both parties, etc., then the terms of that relationship are open to discussion and argument. And discussion and argument is the enemy of any client to a contract, because it just creates that uncertainty and grey area where you're not clear whether you're protected or not. So having partial terms, having heads of terms, they're good starting points. And often we as lawyers, where there aren't clear terms, you start to put together what were the parties discussing? Were there any draft documents sent between the two that we can assume is the default basis for it? But then there are emails which say, well, we don't accept that, we don't accept this. So it is important. The more detail you can get down, the more structure there is there, the clearer this will be. So don't assume just because there isn't a signed contract, don't assume that just because there isn't any paperwork, there isn't going to be a contract in place. If those terms which I talked about are met, there has been offer and acceptance, there's an agreement to have a relationship between the two, if both parties are putting something into the pot, and if there's a degree of certainty over what is going to be provided and what is going to be paid, then you will have a contract. And if you do have a contract, then those terms, whatever they are, whether they are known at the outset or whether they have to be implied by a court later on, will apply and will be in place. So moving on, the next slide and the final slide in this first section is looking at how do you contract? What are the terms that you contract on? And there are generally three ways of approaching this. The worst one, as far as I'm concerned, is often you sign whatever the other side puts in front of you, the provider's standard terms and conditions. And you won't be surprised to think when you consider it that those standard sets of terms and conditions are almost universally drafted to be extremely favorable to the provider. They try and minimize the obligations on them, maximize their certainty of getting paid for it, and reduce the risk on them to as low as possible. And if you do sign up to those standard terms and conditions, and often they say, even if you don't sign these, if we start providing the services they are provided under these standard terms and conditions, then they will apply. And often, frankly, they are not fit for purpose. And we'll cover some of the issues later on, which you should be including, and they won't be included at all in the standard terms and conditions. As Academy Trusts, you are subject to procurement rules. We don't have time, space to cover that in this area, but if you have procurement rules in place and if you are over the relevant thresholds, then you need to be careful to comply with those. And one of the ways you can comply with those is to procure based on, call off a contract under a framework that has itself been set up compliantly. And those framework terms are usually set up by public bodies. They are usually reasonable as between the parties. Key to note that you can't mess around with them too much. You can't amend them. But those framework terms should be far more reasonable and appropriate than contractor standard terms and conditions. But it is important before using those frameworks that you review those contracts and make sure that they are fit for purpose for what you want to get out of it. And finally, the gold standard, you approach a lawyer, ask them to draft up a bespoke contract specifically for you, specifically for your trust, specifically for the services you want to have provided, and that you draft that up. And that will be the gold-plated standard for making sure your position is best protected. But again, as Ed said at the outset, that is absolutely not going to be appropriate and proportionate for your resources to do that for every contract. So it's going to be somewhere between those three areas will be the terms that you contract on. And like I say, proportional depends on how they're drafted, but just make sure they are appropriate for what you are going to be doing. And moving forward on that basis, I'll hand back to Ed to talk about clarity and making sure you get things clear.
Thanks, Matthew. Should we go on to the next slide, Tamar? So where do we typically see things go wrong when we have clients approach us with disputes with their providers? It's not typically on the interpretation of a particular sort of legal phrase or a clause that you might think of as being a sort of a lawyerly clause. It's most typically disputes and misunderstandings around what the scope of services was intended to be, and what the payments obligations were and how they're intended to work. And those things don't need to go wrong. They normally go wrong because there's been a misalignment from the outset as to what the expectations of the parties was. So those disputes, whilst they can be challenging and potentially expensive a year or two into the contract, are resolved at the outset by making sure that you both have a clear understanding what it is you're expecting to do. And so how do you go about doing that? Well, at its basics, it's around making sure that you've clearly expressed what the scope of services was. You've clearly expressed what the payments obligations were, that you've read and understood what the terms are. So even where you're contracting on counterparty standard terms, in a world where perhaps there's nothing you can do to change them, as may well be the case where you're contracting with a much bigger counterparty, have you read and understood what their service delivery obligations are? And are you happy with those service delivery obligations? Because if the contract doesn't describe you as getting something that you're expecting, then they're under no obligation to deliver it. So have you read and understood that from the outset? Are terms ambiguous? And we often see that. That's often an area of downfall, particularly around service scope, is ambiguity as to what was intended. And what we often find, and we're all, I think, guilty of it, is reading a set of terms, reading an obligation through the lens of what you want it to say, rather than what it actually says. So you'll often have an idea as to what the services are, and you'll see enough of that in the service scope to convince you that it tells you that those services are going to be delivered in the way that you want. But actually, if you share that with somebody else, you get somebody else in your organization that doesn't have all that kind of weight of background knowledge that you have to review the service delivery scope, or to review a particular term in the contract and say, what do you think this means? What do you think I'm getting out of this? And just test whether their reading of that is the same as yours. That's effectively what a lawyer will do, what a judge will do. If you come up with a dispute and you then try to resolve it, what does that term mean? Test those really important things at the outset with colleagues as to whether it says what you want it to say. And if it doesn't, change it, or at least adjust it as best you can. And then finally, where do things go wrong? Well, they often go wrong where you're not in control of your obligations. So where there's an obligation in a contract on you to do something, but you can't control your ability to deliver that. Sometimes that's right. Sometimes that's a fair allocation of risk. There's a risk that something extraneous might happen that means that you can't deliver, and that risk has to fall on one part or the other. And you just you agree through the contractual process that that's a risk that you'll bear. But are you aware of, do you understand what those risks are that you're not in control of? And is there anything you can do to mitigate them? And those mitigations might be through things like insurance. They might be sort of practical things that you can do as kind of early warning systems to make sure that you pick things up before they start to go too wrong. Could you have the next slide, please, Tamar? So in terms of avoiding those misunderstandings at the outset, the real drafting basics, and I think to my mind, the fourth bullet point here is probably the most important. It is at its basics. It is an exercise in English comprehension. It's an exercise in clarity of expression, comprehensive inclusion of everything that you want to cover. If it's not in the contract, if the contract doesn't say it, if it doesn't describe a service that's going to be delivered, then there's no obligation to deliver that thing that hasn't been described broadly. So don't think of it as a difficult lawyer's challenge. Think of it as an exercise in clarity of expression and English comprehension. And if you read and get to the end of the contract and everybody is clear what everybody is doing, you're really narrowing down the scope for disagreement and dispute as the contract rumbles on. A logical and methodical approach to drafting, that's certainly what we like to think we're able to add to the process, and certainly that's what we try to train our folks to do. But there's no reason why that logic and methodical approach can't be applied to contract drafting by sort of intelligent, sensible business people. So logical, methodical, don't leave anything to the imagination, and finally focus on what's important in the context. So particularly where you're dealing with perhaps lower value contracts where you don't have the time to spend going through every last clause and every last provision. Think of what's relevant to that particular contract. So don't spend an age worrying about a data protection contract in a contract with somebody that's coming in to cut your grass. Don't spend an age worrying about intellectual property provisions in that same grass cutting contract. But if somebody's coming onto your site to sort of provide some catering services or to cut the grass and will have interactions with children, do worry about the safeguarding provisions and are they sufficiently comprehensively covered. So think about what the contract is and what's happening, and think about what provisions are important to that particular contract. It'll be different from contract to contract. Could we have the next slide, please, Tamar? So in terms of the service scope, it's amazing how often I'll be sent a contract to look at that's been provided by a service provider. I'll be asked to comment on it, and you'll read all the front end, and it has all the force majeure provisions and the notice clauses and the payment obligations in it. And you get to the service scope, and it'll be a sentence, and it might say, hey, we'll cut your grass, or we'll give you access to a platform. And it doesn't give you any more than that. And if it's not described in that service scope as to how regularly the grass is going to be cut, to what standard, by how many people and over how long, then it's very difficult for you, when they're not doing those things to the standard and level that you're expecting, to point to anything in the contract and sort of pull them up on it. So is your service scope comprehensive? Does it describe everything that's being done? Is it clear as to what's not being done? Is it clear as to the standard to which it's being done? All those things which in a year's time you might want to hold them to account on need to be expressed in the contract. It doesn't need a lawyer to develop that service scope in a way that is really clear and is really comprehensive. And then think about whether there are any levers that you can pull to make sure that the contract is delivered to those standards. So perhaps key performance indicators. You might see that in catering contracts that you're dealing with, possibly in cleaning contracts. You might see service credits, so kind of payment deductions, if they don't deliver to a particular standard. And those standards might be measured by things like pupil feedback, by things like wait times at the counter for food and so on. So are there levers that you can pull to make sure those standards are met? Could we have the next slide, please, Tamar? Then the other area, so service scope is going to be relevant to every contract pretty much that you look at. Payments obligations will be the same. It sounds really obvious. Are your payment terms clear? But it's all too common that we look at contracts where they're not. And again, where if you spent the time at the beginning testing it with a colleague, what do you think this means? You'd avoid those obligations or those issues. If I can just give you an example, and it's an example from a school, a contract which had it was a contract for purchase of units of, I think it was paper. And what it provided for was, it was X pounds per unit, perhaps £5 per unit for the first 100,000 units. And then after 100,000 units, the price dropped to £4 per unit. And that sounds like a really straightforward mechanism, but it got into dispute. And it got into fairly protracted dispute, which ended up costing the school a good deal of money over whether that reduction to £4 a unit, once it got to 100,000, applied to all of the first 100,000 units and the 100,000 at first, or whether it just applied to the sort of marginal extra ones over 100,000. It sounds really stupid, but that clause could be read both ways, and that's why they got into dispute. I suspect at the beginning, had you asked them both the question, they might have given different answers, but that would have then easily been resolved and negotiated. Once the contract's in place, you don't have the bandwidth and space to have that negotiation. So it's, as I said earlier, it's testing the drafting. What do you expect it to say? Does it actually say that? And then if you're entering into a relatively longer term contract, you'll want to think about, certainly if it's a service provision contract where somebody's providing services to you, they'll want to think about price adjustment. So is there a mechanism that allows them to increase prices over time, often linked to indexation? Is that mechanism really clear? Are you clear how that would be calculated? Are you comfortable that they can adjust it at all? So think about the payment adjustment mechanism as well as the sort of day one payment obligation. And if we go to the next slide, I think this is back to Matthew.
Thanks, Ed. Thanks, Ed. So I'm going to now have a whistle-stop tour of some of the easy wins that you should be able to make if you can look at a contract and try and get it right. These are the sorts of things where if someone asks me to have a look at a contract, these are where my eyes go to first. These are what I consider some of the most important things that you want to look at and check on. So if we move on to the first slide, the first area or first issue to look at is how long is the contract going to run for? It should be set out clearly when a contract starts and when it ends, usually called the commencement date and the expiry date, so that you know that the service will be provided from 1st of March 2025 and it will run for 3 years to the end of February, bad choice, depending on year or not, the end of February 2028. That's the term of a contract, and it should be absolutely clear within the contract when that term is. At the end of that, the contract finishes and all obligations cease. Now, for some reason, the education sector is one of the very few areas where we continue to have what I call rolling contracts or automatic extending contracts. And I'm sure a lot of you will have come across these contracts which say the initial term is this 3-year term, and you are free to serve notice to bring it to an end at the end of that term. But if you don't, it's going to roll over and automatically extend. And it could be that it automatically extends for the same period of time as initially. It could be extending for a year. I had to deal with a contract earlier this week, which was a 5-year contract. And because notice wasn't served, it rolled over for another 5 years. Clearly, that is, to my mind, unhelpful. And I always advise trying to remove automatically extending terms. If it gets to the end of the contract, you're very happy with it, you like the provider, you want it to continue, then by all means, you can proactively decide to extend that contract. But I don't think that you should get into the situation where you just forgot to serve notice, and as a result, it rolled over. Very common when it comes to schools joining academy trusts, that perhaps someone didn't pick up on the fact that this contract was a rolling contract, and suddenly the first you know about it is when you get an invoice from someone who you thought the contract had ended, and they say, no, sorry, you're now in the first year of another 3-year contract and you're liable to pay this sum. So I don't like automatically extending contracts. If you can negotiate it out. If you can't negotiate it out, then usually the clause says you have to serve notice at least 3 months, at least 1 month in advance. That means that you're perfectly within your rights to serve notice on the very first day of the contract to say, please note, I'm terminating the contract at the end of the initial term, but remember that you sent that, save it somewhere so that there's some paper trail. Contracts can have break rights. They might, for example, be that you can terminate on the anniversary of the start date. That can be helpful, and you might be able to have a right to break the contract at the end of every year. That means you're not exposed. If the contract comes to an end, you can walk away. That's nice and easy. But of course, make sure that you understand if a break right can operate both ways and the risk that might place you in. So from your perspective, it's great to have a break clause that you can bring into play and terminate the contract on every year with 1 month's notice. But if that right also applies to the contractor and they give you 1 month's notice, you will have to find someone else within that month to provide the service. Obviously, depending what it is, catering can take a long time to get a new provider in place. You don't want the contractor to be able to leave you in the lurch. There should always be in a contract termination for breach provisions. And that works both ways. If you don't pay the contractor, they should have a right to be able to terminate the contract. And equally, if they don't provide the service they're meant to, should have the right to terminate. It is surprising how many, going back to my hobby horse before about standard terms and conditions, it's surprising how many times I see standard terms and conditions which contain half a page of rights for the contractor to end and nothing in terms of the client having a right to terminate. It doesn't mean that you don't have a right. There are what are called common law rights to terminate, but frankly, you do not want to rely on those. They're very high bars, they're difficult to bring into play, they carry risk, etc. So make sure you have termination rights for breach. And it's not just about, breaching the material obligations of providing the service. It's about things like you should have termination for breach if they become insolvent, if they have financial difficulties, you want the ability to get out. If they are, as schools and as academy trusts, you are concerned with your reputation. If they bring you into disrepute, if there is problems with them, you want the right to get out. I like having change of control clauses in there so that if they're bought out by some unsavory entity, a tobacco company, a weapons manufacturer, etc., you have the right to get out because you don't want to be in contract with them. So make sure that you have the termination rights that you like. Personally, the best one for you to have in there is what's called the unilateral termination right, where it says the school, the trust, can at any point terminate the contract by giving the other party 3 months' notice. That's a wonderful clause to have in there, because if you're having a problem, if you're having an argument with them about the level of service being provided, and you're going back and forth and there's disagreement, etc., you can use that clause to bring it to an end, and there's no risk of having an argument about it. Looking at the next slide, we do come to performance management. Can we move on, Tamar, to the next slide? Performance management, key performance indicators. I like key performance indicators. I like having service levels set in a contract that says this is the service that you have to provide to this level. And if you don't provide it to this level, these are the financial consequences. It's important that these are set up in the right way. They are not there to generate money for you. Ideally, you will never receive a service credit from a KPI mechanism, because that means that the contract is being provided to the right level. So the key is to make sure that the service levels are set at a measurable, clear level. So there's no disagreement or discussion about it. Don't say the school should be clean. Say that there should be X number of hours provided, that it should meet this standard, etc. And set the level of the service credit, the level of the financial consequence, at a level which is sufficiently high that it encourages the contractor to fix it. If it's going to cost the contractor £500 to fix something and they're only being charged £10 a month as a result of not fixing it, they're not going to fix it. But equally, it needs to be reasonable enough that it's not going to bankrupt the contractor if things go wrong. And have that right to specific termination rights. Some of these key performance levels will be so significant, safeguarding, etc., that breaching them automatically should give a right to bring the contract to an end. The next slide looks at liability, and this is one of the, like I say, one of the very first things I look to. Contractors, providers will always look to cap their liability. And say, our liability is limited to £100,000 in the aggregate over the term of the contract. And the principle of a liability cap is that, or the effect of a liability cap from your perspective, is that if the other party does something that causes you to suffer a loss, let's say they willfully drive a bulldozer through one wing of the school, knocking it over, falling it down, it means there's £3 million worth of damages that you have to fix. And if there's a cap on liability there of £100,000, it means even if everyone accepts and agrees that they're responsible for it, they will pay £100,000 for it, and you will have to pick up the 2.9 million overspend. Clearly not an appropriate and reasonable position to be in. So it is reasonable in the wider picture for there to be a liability cap on the contractor. It's an important thing for their business to be able to say, this is our maximum exposure. But that exposure should be set at a level that is reasonable and appropriate. From your perspective, think about the kind of damage, the kind of loss that could be suffered as a result of the contractor getting something wrong, and make sure that the cap covers that. It shouldn't be the case that a predictable or a foreseeable loss caused by the contractor is excluded because the cap is set too low. And as a result of that, make sure that that is set at an appropriate level. And the last point there, symmetry, if they are asking liability, it is absolutely fair, reasonable, and right that you have a cap on your liability. There will be exclusions, things like indirect consequential loss. Don't have the time to go into there, but that's the sort of a reasonable exclusion to have in there. And there might be inclusions of specific liability for specific things like property damage. So make sure the whole principle of this is make sure that if anyone's liability is being capped, it's capped at an appropriate level in the circumstances, and don't leave yourself with the potential to be picking up the tab for something caused by the provider. Next, looking at some of the specific terms that may or may not be relevant, and Ed picked up on this before. A lot of these will depend on what the contract is and what it's covering. Safeguarding, if the provider, the contractor that you're contracting with is going to have come into contact with your children, your pupils, your staff, etc., the pupils, then you will need safeguarding terms. I have never seen any standard terms and conditions which come close to the level of safeguarding protection that I would want in a contract. So make sure that those safeguarding terms are specifically detailed, are sufficient to protect you, because this is, you will all be aware, one of the biggest red flags going at the moment, as it should be, and you need to make sure that those safeguarding terms protect you as fully as you possibly can be. Intellectual property, if the contractor is going to be creating anything, designing anything, coming up with any sort of materials, etc., who's going to own those? Who has rights to use them? Unlikely to be relevant for a lot of contracts. Your grass cutting contract, as Ed said, no intellectual property is going to be there. But if you're appointing someone to do software, to design software for you, etc., that's going to be hugely important. Equally, data protection. If any personal data, if any information that identifies individuals, pupils, staff, governors, members of the public, etc., is going to be shared between the parties, it is crucial to have appropriate data protection terms there. My colleagues in our data protection team will talk endlessly about how important it is to have all the details set out correctly, because otherwise both parties put themselves in breach of the law. Will there be any TUPE, any transfer of employees between contractors, between the schools, between the trust and the contractors, catering contracts, etc., cleaning contracts? There will always be transfers of staff. You need to make sure that the terms are appropriate there and protect you. Things like, for example, that towards the end of a contract, the cleaner cannot change the members of staff, cannot take all your good members of staff, apply those to other contracts and other schools, and bring in their less well-performing staff to your schools, because at the end of the contract, those staff will then move away from the contractor and on to someone else. The last 2 points, freedom of information and force majeure, those are likely to be important clauses for all of your contracts. Academy trusts are subject to the freedom of information rules. You need to make sure that the contractor is going to support you in helping you comply with those. And ever since the advent of COVID, force majeure and what happens if either party can't comply with its obligations and the rules that apply to that are hugely important, and we want to make sure that they are understood. It can often result in you picking up costs, employee costs, etc., that you may not have been foreseeing. So make sure you understand those. And finally, the last one I'm going to cover at this breakneck speed, and I do apologize because there's a lot to cover here. Some of the issues that we often get asked. Tamar, can we move to the slide? Who are the parties to a contract? As a multi-academy trust, you are the legal entity. You are the limited company. It can't be a school that enters into a contract. That is not an appropriate situation. I don't want to get into the nitty-gritty of what happens if a school is put as the contractor, as a contracting party. It's not helpful. The multi-academy trust should be stated to be the client. Equally, make sure there is clarity over who the other party is, who the contractor or provider is. Usually there'll be a limited company. If they are, make sure you put the company number in there. Don't rely on it, check on it. Company's house, check it. Very often I see a disconnect between the company number and the company name, and companies have similar names, and companies contracts get moved around in companies between a group, etc. The only thing that doesn't change is a company number. So make sure you identify clearly who the other party is. Within the contract, there is often a difference and a divergence in how it approaches doing things. You can have an absolute obligation, so the contractor has to do this, or you can have an endeavours obligation, they have to try and do it. And lawyers will wrap themselves up in knots over the difference between reasonable endeavours, all reasonable endeavours, best endeavours, etc., etc. There is a difference in how this is structured and the interpretation. So look and consider, are they obliged to do something, or do they just have to try and do something? And finally, a question we often get asked, when should the contract be dated? The simple answer is the contract should be dated on or after the date that both parties have signed it. Do not, in big red letters and flashing neon signs, do not backdate a contract. Do not sign it on the 3rd of February and say, well, it apply, you know, the contracts that the services started on the 1st of January, so we'll date it 1st of January. That is very much to be avoided. What you can do is date the contract 3rd of February and say within the contract, these conditions apply from the date the service was provided, from the 1st of January. That's absolutely fine to make the obligations apply from a date in the past, but don't date the contract before it was signed. I think that is a whistle-stop tour of my section. So I'm now just going to pass on to Ed to talk about managing the contract in practice.
Oh, Ed, you're just on mute, sorry.
Somebody had to be first to do that, didn't they? Thank you. So after this section, we'll answer any questions that have popped up in the Q&A. We don't have lots at the moment, so if anybody does have any burning questions, then you've already got a good chance of it being answered if you pop it in now. In terms of the bits that Matthew was covering, just one point on the context-specific terms, and particularly around things like safeguarding and data protection. Matthew's absolutely right. What we often see in supplier standard terms is not appropriate in the context of the service they're providing to a school. Whilst obviously that then triggers a thought process around how do we negotiate and how do we get those terms changed, it should also be a little bit of a red flag as to whether actually they're going to be doing the right thing at all. So if they don't have appropriate data protection provisions where they're going to be managing and processing your data, as is often the case where we look at perhaps with platform providers, that should be a red flag as to whether they're doing the right thing in practice with your data, as well as whether their contract says the right thing. So in terms of diligence on your providers, is the contract fit for purpose is often a good bit of evidence as to whether or not they're going to be a good and compliant provider once you're in contract with them. So contract management, if we could go to the next slide, please, Tamar. So you'll have negotiated and signed a contract that you're hopefully broadly happy with. And the temptation, as Matthew said right at the outset, is very often to stick it in a drawer and only really pull it out when something starts to go wrong. I'd encourage you not to do that. You'll have negotiated a number of rights for yourself, a number of obligations on the supplier, which you want to make sure you hold them to. And the contract is your tool to do that. So if you're having persistently not great service delivery, do something about it. Exercise the right in the contract that you've negotiated for yourself, call them up on it, encourage them to do better, apply the service credit, point to the contractual provision that they're potentially in breach of. And by spending time on those small things, on the little problems, what you'll hopefully avoid is an aggregation of lots of little problems into one very big problem in 2 years' time. It's really difficult when a client comes to us and says, this service provider is not working out, they're doing a really bad job. What can I do to get rid of them? The first question we often ask will be, well, what have you done about it up until now? Do they know they're doing a bad job? Have you told them about it? Have you been kind of on their backs with it? And if the answer is no, and you then try to frame a claim for material breach of contract, it's quite difficult to demonstrate the materiality of that breach if you've never really said anything to the service provider about it up until now. So spending time on the small things makes your life easier either by nipping it in the bud early so that they don't become a big problem, or when it has become a big problem, gives you the ability to do something about it. Diarising key dates is really important. Matthew gave the really important, probably the most common question I get, I think, from academies on contract management is exactly what Matthew described about rolling contracts. You know, we've got 2 months left on the contract. We've asked the service provider to come and take away all the, whatever it was, the printers, the sanitary products, whatever it is that we've got at our school, and they've told us we've flipped over into another 3-year contract. Diarising the date by which you have had to give notice at the beginning and making sure that you then meet that deadline is really important. So look at the contract at the point that you sign it, think about what dates are important and make sure there's a system in place to allow you to identify those dates and to do something about it in good time. And connected with that is complying with formalities. Now, when you give notice to terminate a contract, or when you give any notice under a contract, but most commonly you'll be doing it to bring it to an end, the contract will almost always describe how you have to go about giving notice. And it will typically say something like, you have to give notice by first class post or recorded delivery. It will typically say that that notice is deemed to have been received perhaps 2 days after you post the letter. And if you don't give notice by first class post and recorded delivery, if that's what the contract says, perhaps you send it by email to your usual contract, to your usual contact, say we want to bring it to an end. That's not an effective notice. So that won't have the effect of bringing the contract to an end in the way that you think it does. But there's no obligation on your service provider to pick up the phone to you and say, you know, you sent me this email, you should have sent it by letter. Do you want to go and put it right? Very often, particularly where you have a contract which doesn't really rely on there being a strong relationship, perhaps a platform contract, a sort of software contract, very often the service provider will sit on their hands. They'll wait for time to tick by. They'll wait until you're too late. And then you'll be in discussion with them and they'll say, well, you didn't give notice properly and therefore the contract's extended. And when we're asked, is there anything I can do about it? Usually, unless the contract's badly drafted and we can find a way to help you kind of wriggle out of it, usually the answer is no. Usually the answer is you should have complied with the notice provision. You probably at that point, you either need to kind of suck it up and push on with the contract for the next couple of years, or try to negotiate your way out of it, and that usually comes at a cost. Recording, communicating your concerns, I've touched on earlier. So if we could flip to the next slide, please. Change management during a contract's life. So by this I mean you've started off on day one with a particular scope of services being done in a particular way. Perhaps you want to extend those services or narrow them down a little bit. Think of that process as almost as entering into a new contract. So treat it in the same way, with the same degree of formality, with the same degree of clarity, making sure that you're pointing to the provisions of the contract that it is that you want to change. Think through what the consequences of those changes are and document them. Where we've seen this go, and we saw it quite a lot during COVID, where people had to react very quickly, had to work together in very different ways for all the very best of reasons. But 6 months after the kind of worst of the pandemic was past, people were looking back and thinking, well, actually, what have I agreed? What have I changed? Do I have to carry on working in this different way? How long am I going to be paying these extra costs for these extra services for? And often that wasn't well documented. So think about when you go through any kind of change process with your contractor, how are you capturing that? Are you writing it down? Are you being clear about it? And does everybody understand the same thing from it? And then could we have the final slide, please? And finally, disputes. Now, hopefully, with some of the tips and suggestions that we've made, much of this will be avoided, but inevitably there'll be occasion where you do end up in dispute with your counterparty. In the vast majority of cases, that will never make it to court. Hopefully, in an awful lot of cases, they'll be resolved and settled early. But there will be things that you can do to put yourself in the best position you can and give yourself the most leverage you can get in managing that dispute. You obviously want to avoid it because they're expensive and risky processes. But if you do get sucked into a dispute, then having given indications that service provision isn't standard consistently for a long time, having kept evidence of what that poor service provision was, that can all be really helpful in giving yourself negotiating leverage when you're pointing to all that list of failings to the service provider and saying, well, this is why you're in material breach. This is why I have the rights that I think I have to terminate the contract or to claim damages from you. Without that weight of evidence, it can be really difficult to go through that process, or it's only a lot harder than it would otherwise be. As soon as you start getting involved in a dispute, you should be thinking at least about whether you need to speak to your lawyers to work through what the sort of sensible steps are. There are things that you can do in the dispute process that make your life a lot more difficult, and particularly when you're talking about potentially settling, reaching agreement, potentially giving away sort of admissions of liability and responsibility in circumstances where you would have been better advised not to. So speaking to a lawyer can be a useful sense checking process, even if at that stage it perhaps is only a sense check and it isn't full engagement of sort of a comprehensive legal support. And depending on the nature of the claim, speaking to your insurance provider is a really important step. So if a claim is being, particularly where a claim is being made against you, or where you have a claim which might be covered by your insurance, the earlier you can have that conversation with your insurer, very often the better. What it does is it helps to ensure that that cover isn't voided because you haven't brought it to their attention sufficiently early in accordance with the policy. You might also find that the insurance cover provides legal expenses insurance, which means that you can speak to the panel of lawyers and you get that support for free, rather than having to pay VWV or somebody else for it. So an early conversation with your insurers where there's a dispute looming is certainly a recommended step. That's something we'd always recommend that you do if you were to approach us with a potential dispute. I think that's the end of the sort of delivery bit. We've got a few questions I think have popped up.
I'll start, Ed, to give you a moment to catch your breath and have a look. So reading some of the questions that we've had, if a single academy trust has new schools join, who are the contracts with? Are they the MAT, and do the contracts have to be renegotiated? So when a school joins an academy trust, and whether that's a school joining a multi-academy trust, whether it's a single academy trust joining a multi-academy trust, or whether it's schools that come together and form a multi-academy trust, there will be a transfer agreement, commonly called a commercial transfer agreement. And that agreement will say all existing contracts that school A has will be transferred to the MAT, and the MAT will become the client of those contracts. So essentially, the MAT will take on all the pre-existing contracts that were in place at the school. So they don't need to be renegotiated because they're on the same terms. Now, this is a classic example of what I covered before, in that often the school will have contracts that could have notice periods that can bring them to an end. So the multi-academy trust has a big contract covering all of its schools. The new school coming in has a photocopier contract, has a catering contract. The multi-academy trust would want to bring that new school into its bigger contract because it's better value, it's consistent, it's regular across all the schools. But it turns out that because notice wasn't served, it automatically rolled over and extended, and so you're now in a new term. So the contracts don't need to be renegotiated. They will be the same, but do check before they come in as part of the due diligence process what those contracts are, because the MAT will become the client under those contracts. Another question we had in. Oh, sorry, Ed, go.
I was going to. Do you want me to take the next one? There are two connected to notices, which is the point I was touching on in the final section.
Perfect.
So one question is, if the contract just says in writing, would an email suffice? And another question, is it prudent to give notice at the beginning on contracts? So in terms of in writing, if all that the contract says is that notice must be given in writing, and there isn't a separate notices clause that says how you deliver a notice, then potentially, yes, an email can suffice. But what you more commonly see is the termination provision will say notice must be given in writing at least 3 months in advance. Full stop. And then there'll be another clause tucked away, clause 25 down at the bottom somewhere, that says when you're giving a notice, this is how you do it. And it must be in writing by post or by recorded delivery. And there it's the post, the recorded delivery bit, they kind of trump the ability to serve by email. So you need to look at the service of notices clause, because that is likely to add something to the termination clause that just refers to it being in writing. So you do need to look in a couple of places to see what the mechanism is. And then in terms of whether it's prudent to give notice at the beginning on contracts, so it certainly is a safety net for you. So where would I suggest you think about using that? Well, where you have a contract where you're not really relying on a relationship. So it might not be prudent to do that in a catering contract, because you want a positive relationship with the caterer. They want to hopefully think that they might be in place long term, not just the next 3 years. It might be more prudent to do that where there isn't really a relationship. So a software as a service contract is a good example, where you're just paying for access to a platform, and you might only want that access for 3 years, or you're not sure what you want after 3 years. Giving notice now shouldn't really affect the way the service is delivered. You've still got access to the platform, but it gives you that safety net that you're not going to forget it in 2 years and 9 months' time. So is it prudent? It can be. Do you have to do it? No. If you've got a really good system, a kind of contract management system of diarising notices, you're confident that somebody is going to spot it in 2 years and 9 months' time to serve notice in good time, then that's fine. But it's not imprudent for its circumstances. That's a sufficiently kind of on the fence lawyer's answer, isn't it? But yeah, that's depends on the circumstances. Matthew.
Thanks, Ed. And I'm going to follow that lawyer's sitting on the fence comment on the next one. In reference to one of the early slides in frameworks, did you state that frameworks, when needing to follow procurement regulations, was or wasn't recommended? So the answer to that is possibly, but it depends on the circumstances. So picking up another question, joining the two questions up. Yes, the currently procurement is covered by the public contracts regulations. On the 24th of February, that's going to be overtaken when the new Procurement Act 2023 comes into place, which will take precedence. So in terms of framework agreements, if you are subject to the procurement rules, you have to go through the procurement processes. And currently you have to go through an open or a restricted procedure. It's complicated. It's difficult. If you haven't managed those before, it's very easy to get it wrong. So one of the ways you can make that much simpler is to call off under a framework agreement. And framework agreements should be set up compliantly under procurement rules. As long as you follow the rules in how you call off the contract, and don't change the terms of that contract, you should be deemed to be compliant with procurement rules. So that makes it a lot easier for you. Added to which that framework agreements can often be set up on a wider basis, and therefore can have better prices attached to them than you might be able to individually negotiate if you're a small school, small academy trust, etc. But as I said before, it's really important to make sure that those framework agreement contract terms, which will be different. If you're talking about grass cutting services, 10 different frameworks will have 10 different grass cutting contracts. You need to make sure that the contract that framework sets out you have to use is appropriate for what you want and how you want that service to be provided. But generally, they can be a very straightforward and easy way for you to enter into a contract.
I think there are two final questions, which I'll pick up on quickly. The first one, if contract paperwork left with the departing member of staff, I'm sure the departing member of staff might have checked their confidentiality obligations before departing and taking it with them. But if that has happened, what are your rights in terms of trying to obtain copies of that contract from the supplier? It's quite difficult to know what those rights are without seeing the terms of the contract, but I'd say it ought to be in the supplier's interests to share a copy with you, because if they're wanting to enforce a term against you, it's going to be very difficult for them to do that, to engage with you on it, if you haven't seen a copy of the document. It's a relationship question, though. I think broadly, is there an enforceable obligation that you have against them to provide you with a copy? I think probably not, unless something quite unusual is in the contract. But at a practical level, should they be wanting to provide you with a copy? I'd say absolutely yes. So if there's a relationship, I'd use it to the best that you can to try to persuade them that it would be a good idea to share it with you. And then there's another question on automatic renewals. If you've missed the
Sorry, if I
notice,
can just say it on that last one, I would also very clearly point out to them that if they don't provide you with a copy of the contract and then seek to hold you in breach of the contract or for not having complied with the terms of that contract, anyone, judge, mediator, arbitrator, is going to look very unfavorably on their argument if they refuse to provide you with a copy of the contract, which, as Ed said, is a standard, straightforward, nonsensical thing to do. So you know, threaten them with adverse inferences, good legal phrase, if they don't provide you with that contract.
Absolutely. And then final question, with automatic renewals, you've missed the notice period. Is it worth trying to get out of the new period rather than being stuck with the provider for another few years? Potentially, yes. So there are a couple of things there. There might be something in the drafting of the contract that means although you've missed the notice period, you kind of didn't need to comply with it anyway. So sometimes supplier terms are really badly drafted, even if they're intended to be in their favor. There are often gaps in there that we can help you find, which might allow you to get out of it in circumstances where they thought you're not allowed to. So it is worth stress testing the contract as to what your rights are. If you are absolutely locked in though, and you really don't like the service, then absolutely trying to agree, negotiate your way out of it with them is a sensible thing to do. That's likely to come at a cost though. And the question then becomes, is that cost of getting out of the contract and avoiding their service for the next couple of years, is that worth it for you? And that really comes down to a commercial negotiation. There's not a contractual lever you're pulling, it's a discussion, a commercial negotiation that you're having. But it's certainly worth exploring if you're really unhappy with the service. And I think that's all of the questions. So thank you very much for attending. I hope it was useful. Matthew, I think we'll share the slides and the session afterwards. Our contact details are at the back, including smiling photos of us. So please do pick up the phone if you'd like to bounce anything past us. We're very happy to speak. Anything we didn't cover today. Otherwise, I hope you enjoy the rest of your Wednesday.
There should be a feedback poll which has popped up for you. As always in this type of scenario, we'd be very grateful for your feedback. Should just be a very quick click there. So please let us know how you found today.